Hello everyone, my name is Mike Webster. I'm the Chief Operating Officer of Vox DataVista. Vox DataVista is a leading data privacy software company based both in London and in Scottsdale, Arizona. Today, in our webinar, we will be discussing the subject of COVID-19 and its effects on data privacy rights. We are very fortunate to have with us today Mathew Ryder QC. He's one of the leading practitioners in relation to data privacy issues. So just a little bit about Mathew's background. Mathew graduated from Cambridge and Columbia University and is a member of the leading chambers Matrix. Mathew has a broad practice which includes complex civil and criminal law matters. Mathew is widely recognized as a leading expert with specialist knowledge on issues related to technology, digital surveillance, cryptography, and intrusive powers. Mathew was appointed a recorder to the Crown Court in 2010 and was also appointed as Queen's Counsel in the same year in recognition of his outstanding work both in the civil and criminal field. In 2016, Mathew took a 2-year sabbatical and was appointed the Deputy Mayor of London to lead on social integration, social mobility and community engagement. Now having returned to full-time practice, Mathew has been described as intellectually brilliant and has been consistently listed as a top practitioner in his chosen field. Thank you, Mathew, for taking time out of your busy schedule to be involved in this webinar on data privacy and COVID-19.
Well, happy to be here.
So just to start the conversation, you and other notable legal practitioners were instructed by the Open Society Foundation to provide a legal opinion on the proposed government deployment of, and I quote, a range of digital and data-driven solutions to monitor public health and to provide the government with the information on the spread of the pandemic. Can you explain what those data-driven solutions were and the background to being instructed by the Open Society Foundation to provide the opinion?
Well, a few months ago, we got asked by Open Society Foundation to look into what might be the potential digital solutions, data solutions that the government would be using to deal with the COVID crisis. And at that stage, things were in a fairly early stage. People weren't really sure what was going to be used here. There were some data-driven solutions and digital solutions being used around the world, particularly in places like Korea. And as a result, we were asked to look at it. The firm that instructed me was AWO, who are a new practice involving a lot of work around data and tech companies. And so Open Society Foundation wanted us to look at it with a view to publishing a public advice. And the idea was for the government to understand where they should be focusing and what the concerns were in the plans they had already tentatively put forward. There were 3 main areas. The first was a potential contact tracing app, and we've heard a lot about it since, but the idea was that you put something on your phone that could assist with contact tracing, and at that time the government were placing a lot of emphasis on it. The second was a data sharing scheme, which was being put out through a series of notices, compliance notices that the government had put out as to how they were going to share people's data. And thirdly, really unsure at that stage, but thirdly was an area to do with immunity passports, whether something would be produced whereby you'd have to show your immunity or alternatively some kind of status you had in relation to COVID in order to be able to function at work and other places. So we were dealing with those 3 areas and trying to anticipate what the government might be putting out and explain to them where we thought there were difficulties or problems.
Thank you. So first of all, in relation to the contact tracing, I understand there are 2 models. There is the centralised model and the decentralised model. Can you compare and sort of contrast those 2 models for us, just for the viewers' benefit?
Sure. So there are 2 basic models for contact tracing. The first is a centralised model, and without going into all the detail of it, it's all set out in the advice, but in the centralised model, effectively the government is gathering data from everybody and then looking at that data and matching that data on a central server that would be controlled by the government, and that would allow the government to see where the different matches are coming from, where the likely outbreaks are, and also attach other information to it, potentially things like location data and other things. But at the very least, the government is gathering that information and making the matches in a central way. A decentralized system is much more privacy friendly because it doesn't give the government all your data, and essentially, to put it in really simple terms, the matching is done through people's phones sending out an anonymous signal and other phones catching that signal and realizing whether they've been near that other phone through Bluetooth. And so as a result, what you get from a decentralized system is you walking around on a regular basis, your phone may be pinging around to other phones on Bluetooth. And if someone has a diagnosis and they're found to have COVID, they can anonymously declare that. Then other phones that may have been in the proximity of that phone will be alerted, letting the user know you need to go and get some kind of treatment or assessment. But that's done anonymously, and the data isn't matched centrally, and so it's much more friendly in terms of privacy and being able to ensure that the government has minimum interference and minimum knowledge of the data that's being exchanged.
And at the time of your advice, you strongly came out and said that you felt you had some grave reservations about the centralised model and queried why the government was necessarily going down that route. And as we know, since the time of that advice, the government have performed a U-turn and now have adopted the decentralised model. I mean, what's your view on that?
I mean, I think our advice has been vindicated by the government's approach, and we weren't the only ones. At around that time, for a variety of reasons, people were saying a centralised model is setting a task for the government that is going to cause a lot of problems. It's going to be very difficult to carry out, and is going to be much more privacy infringing than a decentralised model. One of the key factors within that assessment was that early on, in fact before we put out our advice, the two main operating systems run by Google and Apple jointly came out saying they were not going to support a centralised contact tracing system on their operating systems. And that effectively meant every Android phone and every iPhone, which is the overwhelming majority, almost the entirety of mobile phones, would not support a centralised contact tracing system for reasons which now seem very ambitious. The British government decided that it would be able to develop its own app without the support of the operating systems from Apple and Google, and it would be able to do so notwithstanding all the privacy risks that a centralised system had and that Apple and Google were concerned about. Fast forward a few months, having attempted to do a centralised app, the government realises, first and foremost, they can't make it work without the cooperation of the Apple and Google operating systems. And secondly, the need or the justification for doing it that they seem to say was there at the beginning really isn't there when you look into it. And a decentralised model of the one that we were saying was far more likely to be privacy compliant is the one they've opted for.
Some countries, in particular Belgium, within the sort of European Union, have rejected the digital-based system for contact tracing and are relying upon the more tried and tested formula of manual contact tracing. In other words, ringing people up, knocking on doors. So I suppose on a basic level, why have a digital contact tracing system at all?
The question as to why you need a digital contact tracing system is a really good one. And in fact, around the time we were putting out our advice, a body called the Ada Lovelace Institute put out a really good opinion and a kind of assessment of the current position, which questioned whether there was any real benefit in having a contact tracing app. Given that a contact tracing app would always have privacy risks, high privacy risks on a centralised model, much lower privacy risks on a decentralised model, but given that there will always be privacy risks, they were asking, is there any evidence that says we actually need a contact tracing app? The precise question you're asking, why don't we do it the old way, getting notification, people actually going out, asking people who have you been in contact with, rather than trying to do it all digitally through an app, was what Ada Lovelace was saying. They were making the same question. Why do we need it in that way? I think time has shown us that their hesitation or reservations about an app, combined with the way countries like Belgium had approached it, were probably right. We're now hearing the British government also saying, well, actually, the contact tracing app isn't really what it's about. It isn't really that important. It's a nice add-on. Now, that may be because they've run into problems with the one they were trying to do, but it's also because I think everybody's recognizing there is no substitute for the old-fashioned way or the traditional way of doing contact tracing, which is that once somebody gets a diagnosis, you contact them, they come in, they give an interview, they talk to people, and you get a much better understanding of who they've been in contact with and how much. If you're relying on a digital system in the way we're describing, it's much more difficult because you're always going to get false positives by the fact that you may have been near somebody but not in a way that would have caused a risk of infection. You may have a situation where the operating system or the app isn't carrying out what it's supposed to be doing effectively or accurately. And so you're always going to be in a much safer territory when you're looking at real people, asking other real people questions and chasing it up in that way. So I think that hesitation, or to put it another way, the belief that tech will save us and that data will save us, I think all of us that work in data and information know that's a really dangerous starting point. Tech and data isn't necessarily going to save us, and I think we've seen that that's been the case.
And there is also a very high bar from some of the numbers I've seen of it being effective in terms of take-up. I mean, it needs a pretty high percentage, significant sort of number of the population to even take it up, and there have been some sort of studies which have been put out saying that there is some real concern, not just within the UK population, but worldwide about sort of giving information in relation to digital apps and sort of the take-up of those particular applications.
No matter what your legal requirements, you've always got to look at, in practice, how's it going to work? Are people actually going to take it up? If you don't have something which is privacy friendly, are people going to be too suspicious of it to want to use it? And so even if you think as a matter of law or compliance, you can satisfy people's concerns, if they are not confident that the app is going to work well, or that they're concerned that it's going to in some way gather information about them that they don't like, they're not going to use it. And all the rules and all the data protection in the world isn't going to get over the fact that you don't have enough people taking up to make it effective. So one of the reasons why a decentralized, more privacy-friendly model is a good idea isn't just because of the lower intrusion in privacy, but it's because members of the public will feel much more relaxed about taking up a model like that. And the more relaxed they feel, the more people take it up. The more people that take it up, the more effective it's going to be.
There's also been concern raised about the government's apparent lack of transparency in the rollout and implementation of the contact tracing policy and the need for a DPIA, and for our viewers, that's a data privacy impact assessment. Do you have such concerns?
Yeah, I do have real concerns about data protection impact assessment. This is a relatively, in our law, it's been a relatively new thing, came in through the GDPR, Article 35, and the reality is that there are some requirements or some circumstances where a data protection impact assessment is required. Now, you can't skip that process and for reasons of concern or sense of urgency, simply roll out something that you haven't properly assessed. And that means that the Information Commission and various others have to be really thorough in making sure that any proposals are put through the proper processes. The fact that we're in a COVID crisis and everybody understands that and everybody wants this problem solved doesn't mean you're not bound. It doesn't mean, or to put it another way, the fact that we're in a COVID crisis means you're still bound by the rules and requirements of data protection. And a data protection impact assessment is really important. At the moment, there is some litigation going on where some groups are trying to find out, was any kind of impact assessment done? Because it may not have been. And if a proper impact assessment was done for the contact tracing system we have at the moment, was it one that was updated as the system changed? Because it's no good doing an impact assessment in March for the system you have in place at that time, developing the system, and then in June trying to rely on the old impact assessment when you're looking at a very different system you might be rolling out sometime in the summer. And so that requirement is really important, and I think anybody looking at the way a company or a government body rolls out a new scheme or a new app or a new resource, always has to ask itself, have we done a proper data protection impact assessment? What's required? And as we're updating it, is our impact assessment still fit for purpose as we move forward?
The ICO has come in for some criticism in relation to this whole issue because very little has been heard from them about this whole issue of the DPIA. And as the regulator, one would have thought that they would have been right in the forefront of giving the public confidence in the fact that the data impact assessment has been followed through. Are you aware of anything that the ICO has said in relation to the government's position on that at all?
As far as I can tell, the ICO have been quite keen to ensure the rules are followed. I think, without going into the kind of ins and outs of that particular issue or a particular case or litigation that might be pending, I think you've always got to look at the difficulty of the ICO, the difficult situation the Information Commissioner is in. You're talking about one regulator that has to sit across a huge amount, almost the entirety of all data protection in every sphere, in every aspect of society. We're in a COVID crisis. Politicians and the public are screaming out for solutions, and the ICO has to ensure that they don't unduly hinder what are important government proposals in order to protect the public, while at the same time ensuring that they comply. So I do think it's really important that the ICO looks at it carefully. I would caution against prematurely thinking, well, the ICO is not doing enough here or not doing enough there. Until you get into the nitty-gritty or the detail of a particular way the ICO has approached a problem, it can be slightly unfair or premature to be saying, well, the ICO hasn't done enough. But in each area, the ICO has a pretty heavy burden to get it right, and I don't envy their task.
As part of your legal opinion, you also expressed some reservations about the government's plans on sharing and sharing and storage of personal data. Can you elaborate upon those concerns? Yeah,
I mean, we set out the concerns we had about data sharing in the advice. It's one of the most significant portions of the advice in the sense that of all the things that we were dealing with, we found it hardest to understand how the government had complied with the kind of procedures it needed to follow in order to share data properly. If I try and explain it, it's at risk of getting very, very technical. And even those of us who are very interested in data protection information law know that as you start to talk about the detail of it, everybody's eyes glaze over, even your colleagues. So all I would really say about it, subject to going into detail of advice if you want me to, is that realistically what the government was proposing was a kind of data store in which different organisations and bodies are going to share information. And in a rush of enthusiasm, which often takes place around tech and data and information, government ministers and various other people were saying it would be great that we'll be able to share information really easily, and different corporates and different agencies will be able to use and process information in a way that will give us amazing new solutions. But in reality, you have to ensure that you go through the right processes and the right authorizations, issue notices in the right way to make sure that you are not sharing information or allowing corporates or organizations to process data in a way that hasn't been properly authorized by law. And we're all familiar with circumstances, particularly in the field of health data and NHS data, where you can be hoping to share information to get great new innovative solutions, but what you're not doing is going through the right processes to make sure that the assurances that have been given to patients and that people's sensitive personal data, particularly for sensitive processing, has been properly safeguarded. And we set out in our advice that we thought, while we understood the desire to go do that kind of work and the enthusiasm to have people working together on processing and sharing data, we didn't think that the right procedures had been followed, and the notices that had been issued didn't seem to cover all that they were supposed to cover. So we're hoping the government has looked into that in some detail. Not confident that they have just yet. But for me, it was a really good illustration that underneath big announcements and underneath exciting proposals, you always have to check the small print. you always have to dot the I's and cross the T's, because in this particular field of data protection, one slip in the excitement of sharing data and getting new solutions can mean that people's data is not properly protected, and that can have really, really serious consequences for enforcement and various other reasons for any of the organisations that are sharing that data.
Yes, a very, very important issue. I'd like to change tack slightly and talk about passports. As we know, the history of passports is a very controversial one. I mean, passports first came into being just over 100 years ago in the as a result of the First World War, and in fact as a result of the Spanish flu.
Sure. Yeah.
So there's an irony there in terms of the ability to be able to track and trace and control the movement of people during that pandemic. Coming forward 100 years, we now have a discussion about immunity passports. I wanted to raise the question about what is your view on the whole question of immunity passports, and how likely is it for an immunity certification policy to be introduced?
It's quite hard to tell at the moment, and I think realistically when people talk about terms like immunity passports, it's similar to contact tracing. Those expressions can mean different things to different people, and you have to get into the detail of what people are talking about to understand exactly how serious the proposals are and exactly what the implications of those proposals might be. I think when it comes to something like a COVID immunity passport, one of the things that's important is to work out whether this is an attempt to assess whether people who are coming into a particular jurisdiction or are trying to do particular activity, whether you are actually assessing whether they might have COVID symptoms. That's one thing. Or whether alternatively, when you are allowing people to travel or you're allowing them to do certain activity, whether they're having to verify that they've got some kind of certificate or they've been through some kind of assessment that gives them some authoritative pronouncement that they're not contagious or that they don't have symptoms. Now, those are two different things, because one is assessing them and the other is simply verifying their status. And part of my work, quite separate from the work I did on that advice for AWO, has been a review I'm chairing of biometrics in conjunction with the Ada Lovelace Institute that comes out of some government work that was done last year, where we're trying to understand and look in detail at the way biometric data is regulated within British law and whether that regulation is fit for purpose or whether there are problems with it. And I think one of the really interesting issues that the immunity passport throws up is how much will biometric data be used in that context? How much are you going to be assessing physical attributes of people when you're trying to do some kind of immunity passport assessment? And also, how does that correspond with the protection that biometric data is given in British law and European law? Because on one view of it, you can have an identification or a verification system that doesn't engage the biometric regulation at all, but nevertheless is still very sensitive. I think one of the important things we're going to have to confront as a society, nationally and globally, is that the concern about pandemics, the havoc that infection and pandemics can cause for the economies, for global movement, for societies in general, means that there's going to be much higher levels of sensitivity about how you assess who may be contagious and who may have illness, and what you do if they show symptoms or they don't meet certain verification standards. And as we're doing that, we have to make sure that whatever mechanism we're using to verify people doesn't become some form of global identification card that can be discriminatory or can cause people problems in other ways. There is a real danger here that for good reasons of wanting to protect people from COVID, we can end up with identification and verification systems that can be very detrimental to certain parts of the global population. And so as we roll that out at governments of all levels, we're going to have to really look carefully at how it complies with data protection, how we can make sure it's minimally intrusive, and how you can ensure that it's not discriminatory in the way that it impacts on people when they travel or when they work or whatever. We're talking about this we're talking about it as immunity passports, but we don't necessarily mean passports just in the way of travelling. what you're talking about is a verification status or a verification identity. And that might mean some kind of verification process in your work, in what activity you're allowed to do, in whether you can study. And I only have to state that to make it obvious the implications for everybody in ensuring that they have that kind of status is going to be very, very important indeed. And you've got to take into account there are many, many people across the world functioning in society, contributing to society, paying into society, who don't necessarily feel confident about their documentation or their papers. And if you add a layer of COVID immunity or some immunity passport to the requirements people have to present when they're trying to work or get education or access health services, then you're in danger of alienating a huge amount of people who can't get their paperwork together, and as a result will try and opt out of the system altogether, which is dangerous for everybody. Yeah. Sorry, really long answer there, but yeah,
no,
you can chop it up.
But very, very interesting and very informative. Just sort of bringing it back to the sort of domestic market, and just touching on again on the sort of contract tracing policy. Assuming that the app is rolled out, I just wanted to touch on the whole question of individual rights. And how would, for example, in practical terms, a member of the public be able to challenge, for example, a request to remain at home for 14 days on the basis that an app has said that they have been in contact with an infected person? I mean, there are lots of issues around that, obviously the accuracy of the app and what rights of appeal one has under natural law in terms of being able to look at that. And I wondered if you had any comments on that particular point.
Yeah, I mean, I think what's interesting about this area, and one of the reasons that probably I was instructed to give an advice with some of my colleagues, was because what you're talking about is a interface or interplay between data protection law and many of the requirements that the government must follow in data protection law to ensure that they act proportionally and in a way that is data compliant, with human rights law generally making sure that people aren't improperly prevented from going about their activity, freedom of association, all sorts of other things, fundamental rights which people have in society aren't disproportionately impacted. We all understand, I think every sensible person realises the need of the government to protect everybody, all its citizens, from infection. And I think most people will understand that you have to take steps to do that, even something as drastic as lockdown that we've been under, people will understand that. Where it becomes harder to understand is if you are not relying on accurate information, or people don't have confidence in contact tracing apps or other forms of solutions. And as a result, they feel that their right to associate with people, their family life and other things are being disproportionately infringed. And the process for that will be litigation, which will challenge the government's processes to ensure they've been compliant with data protection law, but also to ensure they're compliant with human rights law. And both of those things are going to be important moving forward. We've seen a lot of lawyers expressing opinions about the COVID regulations that aren't just about data protection, that are about freedom of association, that are about privacy and all sorts of other things, and sometimes about basic elements of criminal process and fair trial as well. And you're going to see, I think, COVID regulations which affect people in a way that they are uncomfortable with, attacked with a variety of legal tools.
The COVID-19 pandemic has been unprecedented. It's been an unprecedented event in our lifetime and has raised a number of sort of data privacy issues and really tested our current regulations. Almost with hindsight, and sort of looking at our current GDPR regulations and other related legislation, do you think there is sufficient protection for individual rights and data privacy as it stands at the moment?
I think there's a couple of interesting things you raised there. The first is I don't think we've got hindsight yet. So I think it's going to be a few years before we'll be able to tell, probably a little bit of litigation still to go, before we'll be able to tell whether our regulatory framework and our legal framework around data and data protection is sufficient. The jury is still out, people are still working with it around all sorts of the issues we've been speaking about. The legal solutions and the legal answers haven't really been tested, and we don't know how effective they are yet. I do think, though, that this isn't an area where we should be unduly pessimistic. There's an element of patting on the back that can go on, particularly in Europe, where could you imagine if this had happened 5, 6, 7 years ago, where we didn't have GDPR, we were still operating under an old system, we hadn't updated our data regulation, and as a result we were trying to scramble around to get up to date while we were in the middle of a pandemic. So there is some element of comfort we can have from the fact that GDPR came in, and it's post-GDPR that we've then been confronted with all of these issues. I do think, generally speaking, the GDPR framework and the way we've had to work with it has been a good starting point for us to understand how we would regulate data and how we would protect privacy under the most stressful of circumstances like a global pandemic. So I do think this has been a good starting point, and I do think we may find, we don't know yet, but we may find that the GDPR will be regarded as having done quite well in terms of coping with this kind of crisis. But the issue will always be enforcement. The issue is always going to be how effectively did the regulatory bodies within different jurisdictions carry out their enforcement? How did regulations, for example, across Europe interact and align with different regulatory frameworks in other jurisdictions, which could be as varied as the US or China or India or various other places? How do they fit together? And the forthcoming test for it is going to be how do we work that through on a global level where people are traveling between jurisdictions, and so the problems of COVID, dealing with people's data, how you assess people, is going to be global and international, but you're dealing with different jurisdictions with different legal frameworks. And the GDPR may be seen by some as a model for how other jurisdictions across the world should be carrying out their own protection. But we'll have to see. At the moment, I think the GDPR is probably looking quite good compared to some other systems.
And finally, looking forward, are there any other big data privacy issues that you can foresee on the horizon?
Yeah, there's a few. There's always a few. But I think that one of the key things I'm looking at the moment in a lot of detail is how we're using things like facial recognition, how we're using biometric systems and new biometric products. I think as a matter of kind of current events, we're talking a lot about COVID in the course of current events. It's easy to forget that in the middle of COVID we've had the whole issue around the police killing a black man in the US and the kind of global concern that's raised about policing and discrimination within policing. And what was really interesting for me in that context is that very shortly after that, a number of large data-driven or tech companies like IBM, Microsoft, Amazon, all declared in early June that they were going to stop allowing law enforcement to use their products for facial recognition until there had been a proper framework in place. Now, it's a really good example for me of how a major world event like that has caused tech companies and data companies to consider their own involvement in that kind of discrimination or that kind of activity, and a very, I think a very good desire, very healthy desire to say we want to make sure that the products we're building and putting out and that we're relying on don't repeat pre-existing discrimination. So I think that's a really positive way for tech companies and data companies to approach and respond to current events. But I think we're going to see a bit more of that. I think when we're looking at, for me, when we're looking at AI, the development of algorithms, the data that's involved in that, there are going to be companies that will be reflecting much more deeply on how do we ensure that the algorithms that or the algorithmic-based products that we're using are not discriminatory. How do we ensure that they meet minimum standards? What should those minimum standards be? Part of that will need to be tested under GDPR law, but I think a really healthy part of that is going to take place out of court, not litigation, but will be legal advisors in-house and through legal firms talking to companies about how they can produce their products in a way that everybody can be comfortable with and that meet standards which are going to comply across the board. And I think that's a really positive sign for the future. These are difficult issues. Before 2020, we knew these issues were coming. But I think if there is a silver lining to the very black cloud that 2020 has been so far, it's that people aren't looking short-term about this. They're realising how we need to grapple with data and information issues, get on top of the law and regulation, and find a way to make the products that we're all going to use more and more and more comply with that. I worked in City Hall in London for a couple of years, took time out from being a lawyer and did that. And one of the things that was really obvious to me when I travelled around the world, visited other mayors in other major cities as well as working in London, and I did a lot of work around data in London for the mayor, was that public bodies, local governments, city mayors, are increasingly going to have to use more and more and more data, generate more data for the people in their cities in order to be able to provide effective services and do so in a cost-effective way. So the need for every single public authority to have products and legal advice and to be able to access those things in a way that gives them confidence about the data that they're using and gives the public confidence is going to be critical 2020 onwards. So for me, I think there's lots of issues there, but that's going to be a really positive way forward that all of us who work in this area are going to have to think very carefully about.
Well, thank you for your insights into the future, and thank you very much for your time today on this interview. It's been a great privilege to be able to interview you, and I hope the viewers have had an opportunity to take on board all the things that you've pointed out, and thank you again.
Well, thanks very much.